So allow me to introduce the speakers and the moderator for this session. We are very privileged to have a very esteemed panel joining us in this discussion. We have Dr. Professor Heinz Goddar, partner Boehmert and Boehmert, an esteemed German patent attorney. He teaches IP law globally. He is also a former president of LES International. He is a Hall of Famer in the IP world. Please give him a big round of applause and welcome you in this session. Kindly be seated, sir. Very warm welcome to you. And let me introduce the speakers for this session. We have Ms. Chitra K. Iyer, Director, Licensing Program Leader, Phillips. She's a versatile professional and she has excelled in new drug discovery, and she now leads Phillips licensing program with prowess. So kindly welcome Ms. Iyer. Please give her a big round of applause. Very warm welcome. Iyer ma'am, thank you so much for joining us. We have also Mr. Prashant, Phillips Executive Partner, Lakshmikumaran and Sridharan attorneys. He is deeply involved in patent prosecution and litigation. He specializes in software, telecom, and electronics. Well done, welcome, Mr. Prashant Phillips. Big round of applause for him as well. We have Mr. Vinayak, who is patent, IPR, and innovation leader. And with 17 plus years in IPR, Mr. Vinayak manages all aspects from budgeting to litigation. He is a global leader in patent strategy. Mr. Vinayak, thank you so much, sir, for having joined us. A big round of applause for Mr. Vinayak as well. We have Mr. Pankaj Soni, partner and head patent litigation from Remfry and Sagar. He is licensed in India, NY and NJ, and he leads patent litigation, advising Fortune 500 companies on IP portfolio management. Very warm welcome, Mr. Soni. Thank you so much for joining us in this program. And we have Mr. Gaurav Sawant, Associate Director, Patent Search and Analytics, Clarivate. He leads a team of SEP experts specializing in 5G, 4G, and video and audio codecs. Please give him a big round of applause. Big round of applause for all of the speakers. And as you can see, it is a very, very esteemed and distinguished line of guests who have joined us. So navigate with us. It is not just a session. It is a setting sail into the future of licensing with Innovate, Protect, and Scale. So without wasting any more time, I'd request Dr. Professor Goddar, partner Boehmert and Boehmert, to kindly begin the session. Over to you, sir.
Yeah, good afternoon. It is not to wake you up. I know that you all are very awake, but maybe you are a little bit tired because the day was long and many subjects to be digested, not only listened to and written down, but no, there's no writing down anymore. It is only electronically somehow recorded. In my time when I was sitting in conferences as audience, I still had to write what I heard, but this is over. Now, what we wish to talk about here today, and you see the panel is complete. I think I don't introduce each and everybody here. You have them in the newest program, which you got here. And we will do the following. I will first try to introduce into the FRAND problem in general in about 5 to 7 minutes, starting, of course, from the continent where I belong to and even a certain country I belong to, namely Germany. And then we will move to the panelists, which will be in the order according to what I had written after a preparatory session we had, of course, properly some weeks ago already. Actually, it is Chitra, Iyer, Prashant, Phillips, Vinayak, Katkalambekar, Pankaj, Soni, and now we have also Gaurav, Sawant, of course. We add you at the end if you not. It's no ranking, it is only because of the order in which I was informed of the participants, whom all I very much welcome. But let me talk a little bit about the general situation. And I would say I don't know whether everybody has the newest version of the program because it changes every day. I get it always for breakfast, more or less, and today was another version which kept me a little bit away in a different session under the leadership of Danpan Agarwal, my dear old friend, and that was unexpected on financial aspects of intellectual property. But now I am fully here with SEP FRAND because this is something which is very close to my heart for a very simple reason. You have in the telecommunication world, you have a certain group, they were implementers, notably, for example, the German car industry, Daimler, BMW, Porsche, Volkswagen, you name it, and Bosch, not to forget, Bosch is the biggest German car maker. People don't see this at a car, but when you take the nice brands and the body of the car away, and you look what is inside, it's always Bosch, 80% or so. This is a very, very well-known, not a secret at all, but joint development of German car industry, of certain components, etc. All classical cars with nice combustion engines, of course, and now they are struggling in order to, well, to follow somehow their biggest customers, which is Chinese, I would call them customer industry. That means the biggest market for German car industry is China. They make 3/4 nearly of their profit there, all over the place. And so this is a big question. In telecommunication, however, Germany has no own telecommunication business. They have business, but not real manufacturers. The players are the Huaweis of this world, the Ericssons, the Nokias, the Qualcomms, and they own huge portfolios of standard essential patents, or SEPs, we call them shortly, and they wish to monetize them, which is very legitimate. And the implementers, at the time when you could still separate these two groups, they wish to get it as cheap as possible, and the others, the owners of the intellectual property portfolios, wish to sell them as expensive as possible. And a fair balance has to be taken, and you know that in Europe we had a basic decision, 2014 I think it was, Huawei versus ZTE, where the European Union Court of Justice has determined a basic rule for how to license SEPs to implementers of any kind. And they have set a certain procedure which had to be followed. Essentially it is that somebody who owns, which is permitted, a patent or a patent portfolio which is essential for access to a certain technology. Let's say, in a very primitive example, the 2G world, if your phone, my old Siemens phone, which I have here from 1998, still I have also an iPhone, this is in the other pocket. If you wish that that phone can talk with a phone in, no more in Japan, it never did. Japan had a different standard. In India it still works if the network is not too busy. In the United States it works, of course. They are very, very, I should not qualify this, but compared with China, this is an underdeveloped telecommunication country, of course. China is every 5G, 6G, whatever you call it, and the United States is struggling to come to that level also. And I see this with my iPhone here, which is 5G, of course. Germany, everything nearly is Huawei, if it is 5G, and it is very fast. It has huge bandwidth, and it never breaks apart a connection. If I come with the same thing into a so-called 5G system in the United States, I know already without designating any name which system is being used there. It is a 5G system, but they are just not so good. Anyway, what the European Union Court of Justice said in Huawei versus ZTE is that owners of standard essential patents, that means a patent which is necessary for my phone to phone or to understand, to speak with a phone in somebody else's technical world, that you have then to license under fair, reasonable and non-discriminatory conditions. This is what the court said, and they said also that a certain procedure must be followed. That means to be licensor, the owner of the patent normally it is not a patent, it is a patent portfolio of several hundred or several thousands of patents, which the other side needs, has to make first of all, to make a offer to the to-be licensee that he is willing to give. He will contact the to-be licensee and say, you are using my patents and you infringe, and I would like to sue you if you don't take a license. And there the European Union Court of Justice said, no, that is not the procedure. You have to make the offer to license out under FRAND conditions to them. And then the question is, who has to give an offer first? Who is then the next one? What is the next step? It's a little bit complicated. It takes a few years, and there's of course disagreement in the, let's say, camp of the implementers on one side and the camp of the people who have the SEPs on the other side, which procedure precisely follows out of Rubble versus ZTE. And it is by far not over. The court battles are going on in Germany. In the major countries, Germany is the country where about 80 to 85% of all European patent litigation takes place, not because the Germans are so litigious, but because it covers the biggest market. If you get an injunctive relief decision in your favor as a patentee, in Germany you can close 30% about of the GDP of the whole European Union, so you don't need to go to courts in other countries. Usually also litigation takes place in Britain, and that's it more or less. It is Germany, Netherlands for certain purposes, and then Britain. There the litigation takes place. Very complicated, very, however, costly, very lucrative for intellectual property law firms. And now you have a very interesting phenomenon, because we have since 27th of April of this year, actually, a proposal of the DG GROW. This is one of the Directorates General of the European Commission under DG GROW, where they propose something totally different. They say, we don't wish these costly court procedures anymore, which make it in Europe, with all due respect, difficult for small and medium-sized enterprises who wish to enter the market. It is too costly, too complicated, and the Commission says, no. We wish to have a neutral way outside of the normal courts, of the civil courts, where hopefully in a peaceful manner, also with cross-border effect, because we need to talk with other countries, with mainland China, with Taiwan, with Japan, I don't know what, probably with India also. We need to come to some generally accepted procedure to come to FRAND conditions for SEP licensing without using civil courts, because that's what the Commission says more or less. They have proven to be not able to harmonize this whole system, and it is too complicated and too costly. And I wish to briefly explain, and then the speakers come, what this SEP regulation in Europe does. It's very simple in principle. They say, before you can go to court with a so-called self-declared SEP, that means I declare my patent is standard essential for a certain standard. You have to go into to be created still, patent IP center or patent center at the European Union Intellectual Property Office in Alicante, which does until today only designs and trademarks, but they will have a new division, let's call it, and it's a big dispute now who will be the members who decide there, etc. Big dispute, and you have to notify them, here, this is my self-declared SEP. You do not tell only ETSI, the European Telecommunication Standard Institute anymore, or IEEE or so. You also will have to inform this IP, or let's say Patent Competence Center at EU IPO. Why EU IPO? This is different from the so-called European Patent Office in Munich, which is a private organization. Certain countries have agreed that their patent granting procedure and examination and search is somehow centralized there, but this is not an EU institution. That means the European Union Commission, supervised and reporting to the European Union Court of Justice, cannot tell the EPO, you have to do this and this and that. Nothing like that. EPO is totally independent from them. So EU IPO is an agency under the Commission. So they will in future have to be in the driver's seat, the Commission thinks. So you will have to notify them this is a standard essential patent. That's the first condition. If you don't do this, you can never go to court with any request for damages or injunctive relief anymore. So this is now in the central register. Next step is, before you can go to court, that's not the end of the litany, before you can go to court with an injunctive request, for example, against a implementer, you have to go through a mandatory essentiality check. That means the IP Competence Center of the EU IPO will determine whether your self-declared SEP is really an SEP. That means it cannot be bypassed. If your phone wishes to talk with the other phone, it has to follow a technology which uses that patent. Mandatory. Next step, can you go to court now? Oh, no. You must now go into a mandatory arbitration procedure, which actually is more a conciliation, mediation procedure at the same patent competence center at EU IPO, and they will determine a global maximum aggregate royalty, which that product, from their viewpoint, can carry in order to be competitive in the market. Because as we all see, we know this from practice, I do a lot of litigation work in that field, if you come to an accumulated royalties, taking royalties one on top of the other of 52%, which was once in GSM 2002, which was offered to a Chinese company, client of mine, that means it is unmarketable at the end of the day. So maximum aggregate royalty. After you have done all this, you can go to court and you can ask them for the normal injunctive relief, for damages, whatever is possible. Now, there are many steps here which I cannot explain here in terms of shortness of time, but what I made available to the panelists here, and I can also send it to the organizers, of course, there is a book, 600 to 700 pages already, of consultation papers which industry of all sorts, both from the sides of the people who have the SEPs, that means the Qualcomms, Ericsson, Nokias, and many others, also Huawei nowadays, they all have their packages which they wish to license out, and they have given comments on this procedure. The implementers, the only implementer I know of who has really unanimously, highly welcomed the system is the VDA, the Association of German Car Industry, because it is definitely in their favor. I think they will get, in other words, FRAND licenses in future much cheaper than in the past, if that procedure passes. There is now a consultation period. It is continuously extended by 1 or 2 years, but one thing should be kept in mind, and then I'm finished, that by the end of next year, no, this year in the meantime, the Commissioner Breton, who is the head of, he's overlooking DG Grow, he is determined to leave this regulation, draft regulation of 27th of April of this year as his legacy as a law in Europe. And regulations, as you know, are immediately applicable laws in Europe. They are not directive to the government where the individual countries in the EU would have to implement. No, it is immediately applicable law. You can imagine what a consultation mechanism is at the moment running, and I think patent departments, licensing departments of big car makers in Germany, of telecommunication companies, of the companies like Bosch or semiconductor companies, they all are running at each day through the doors of the Ministries of Justice and going to the European Union in order to influence still this legislative process. Having said this, we come now to the real contributions. I start with somebody I don't know whether here Chitra Iyer, who comes from Phillips, is a company which is an implementer, certainly not. I sit on 4 IP Council with some dear colleagues from Phillips also, with Jakob Eleveld and with others, and they are half implementers, half owners of SEPs, so they have their own viewpoints, and we will hear from each and everybody of the panelists, but from their viewpoint, from a territory which is influenced at the end of the day by SEP FRAND discussions, will have some interest. And we have chosen freely, somebody is from India and talks about United States, or about Netherlands, or Europe, and you are the first one. Please, go ahead.
Thank you, sir, and good evening to everyone. I know it's the last panel probably and it must be tiring, so we'll try to keep it as lively and engaging for you. So I think Professor already covered in detail what an SEP is. I think one aspect I wanted to add is an SEP is very different from a regular patent because you have to declare. So the person who owns the technology, the patent owner, has to voluntarily file a declaration where they say that, look, this is an SEP, and that also means that they are obliged to give that particular technology on a fair, reasonable and non-discriminatory terms. Now, while these words seem very simple, I know that people who have been in the courts know that how difficult it is to get interpretation of each of these terms, to understand what it really means. Now, the thing is that it's not only now in Europe, but what does it mean in each and every court, in each and every country? You know, it's become a very nuanced and a very complex subject as it is. So what I'll probably do is, we have a panel here which well represents different aspects of SEP. I'll talk a little bit of the overlap of what's happening in India, very, very high level, academic. And again, these are my personal views, not of my organization, because we are very much in the court and file quite a number of cases in the Indian courts. So I'll keep it academic, and this is not my company's view. These are my views. So Phillips in fact started the first case in India in 2009, probably way ahead of the Huawei ZTE judgment which Professor spoke about. Huawei ZTE, when it happened in Europe in 2015, actually defined how a licensor and a licensee need to behave during a negotiation, which was very undefined. For example, you go and you ask for you say that I have a patent, I want to give you a license. There are 100 different ways the other party might behave. So the Huawei ZTE actually defined how the behavior should be between both the parties. But Phillips in India filed way ahead of that. We filed the first case probably. We've been trying to negotiate. We were very active in the DVD space. The Phillips DVD, the DVD, CDs and all of that. So there were a lot of infringers in India violating the patents. So 2009 was the first case, which was finally decided in 2018 after a long battle. That turned out to be the first SEP judgment in India, which was a pro-patent judgment. So right after that, we filed 3 or 4 more cases. So this was in 2021, 2011, 12, 13. The jurisprudence was very slow, as you know, because we didn't have a structure even globally. 2015 is when things started taking a turn, and we had the first Dolby started filing. Before that, slightly 2013, we have the Ericsson cases, Ericsson Intex, Ericsson Lava cases, and a lot of interest started in the Indian ecosystem. What is this SEP matter that's come up, and what is this litigation that's come up, and what's happening here? And India was also at that point, I would say, early 2011, a very, very implementer kind of a country. We are very different right now. I would say 10 years back, we would not have thought where we would be today. But we were at the point where the smaller companies would think that they are being, harassed by the bigger MNCs who are technology owners. So to come back to 2015, the Dolby cases started really defining Dolby versus Oppo, followed by Dolby versus Vivo, rapid settlements. It actually defined how the SEP landscape in India is growing. Gradually, we started coming to a point where the Indian courts started believing that, okay, in India the court cases take a very long time. We have to, compensate the patent owner somewhat in the interim stage. And there developed the jurisprudence of a pro tem or an intermediate kind of a respite that's given to the patent owner. Now, India is a very different country from Europe. It's different from UK because the court cases, they move very fast over there. The FRAND determination is very fast. The system is more efficient. Similarly, in Germany, the validity and infringement is handled by different courts and it's very efficient. We are not there yet. So what do we do in India differently? Keeping in mind the huge load of the judges. The judges came up with an interim kind of a solution where in the pendency of the suit, there will be something known as an interim arrangement that can be provided. So at this present time, now post the Ericsson matters, we had a series of Phillips matters where we got very good interim arrangements. Phillips versus Xiaomi, Phillips versus Oppo, Phillips Vivo, and Vivo was a landmark decision in that respect that they said they don't have money, so we said, okay, you give us your asset in India. And they gave us a piece of land that was around $40 million at the time. it's probably more, I don't know. But that started actually defining the jurisprudence, that the court believes that the mindset, there is also the question of equity, courts realizing that a patent owner who has spent a lot of time and money in research needs to be compensated somewhat. So that's where we are in terms of jurisprudence. Interestingly, at the point in time when Europe is grappling with essentiality checks and everything, defining an expert, who this expert is going to be, we in India are a very different country in my view. We are not there, we don't have this kind of experts. But I do feel in my own view that we need to have a balanced policy, because Indian innovators tomorrow could be in the same position as the MNCs are today. And that's how China was a few years back. So we have to be very open about the fact and very likely that about the possibility of that happening in the future when we develop our policies. I'll just stop over there, let my other panelists talk and can come back to this.
Yeah, thank you so much, first of all. And now I would like to ask Prashant to share his thoughts on this whole situation from your personal experience or whatever you are interested in here, what is in India. Particularly, I'm interested to hear whether in other regions, countries than the European Union, there are also attempts to take SEP disputes out of courts. That would be very interesting to hear this, because that seems to be a globally accepted, I would say, necessity even, because otherwise we have these nice things, this nice invention of cross-border injunctions which are overlapping then at the end of the day. When the United States has started this in a procedure in which I was myself involved, Microsoft versus Motorola, a long time ago, we had a nice injunction obtained here in Mannheim in favor of Microsoft, and a US court in Seattle said, oh no, this is not applicable for the United States. So this cross-border thing is something which normal courts cannot solve. We need some other institution to do this. So everything is fine, however, but if you have an idea about what other things outside of course courts could be done, would also be nice.
So thank you very much, Dr. Goddar, and good afternoon, everyone. I'm sorry. I hope I am audible. Yeah. All right. So what I just would want at least to refer to Professor Goddar's initial description of the proposed framework in Europe, which focuses, or which also in fact proposes that certain discussions or mediations or general agreements be put in place, particularly when we have issues which can be resolvable between parties. And this is something which, at least in my view, it definitely is a novel approach towards resolving such kind of disputes, particularly pertaining to SEPs. But it is not something that is totally, an island in itself. There is a basis in law generally as well. Generally in law, disputes, which are, there are two broad categorization of such disputes. There are, rights in rem as well as rights in personam, and any disputes which involves such rights are resolvable before different forums. So generally when we have in rem rights, and if there are any disputes pertaining to such in rem rights, then we have the courts to resolve such disputes. But however, when we have in personam, that means when we have resolvable issues between parties, we have a mechanism which are generally referred to as alternate mechanism or alternate dispute resolution mechanisms, which the parties can in fact rely on to reach a common consensus. And by far, arbitration as a mechanism has seen acceptance globally. Whatever is decided by the parties, between parties, is enforceable before courts as well. And that is something which forms, I would say, the foundational principle, even for what has been proposed under the European framework. That said, that is also not something which is, new to India. There have been cases in India which have in fact accepted the possibility of arbitration, particularly in the context of IP disputes. Again, the fundamental principles remain the same, wherein the disputes which involve rights in personam are something which could be resolvable through such kind of engagements between two different parties. By and large, at least in India, what we have observed, one may, in fact, the first question that may actually come up is that if universally there is such a concept available, India also recognizes the possibility of such a framework being adopted by parties, then why is India in fact lagging behind? The reason is because many a times while we are seeing the parties that are involved, particularly when we look at SEP disputes 20 years ago versus the SEP disputes which are currently right now before courts, there is a general disagreement, at least in terms of what should in fact be the royalty rates, or whether in fact even if the parties are themselves inclined to pay such a royalty rate, being asked, validly so in a predominant number of cases, by the patentees. So those disputes land up in court, and those are something which at least the parties would want or can in fact resolve outside courts. But one common thread is, or what I would say is, or perhaps could be one of the few issues, are as follows. That many a times when we are looking at licensing agreements, particularly involving territorial aspects, because when we have different players in different territorial jurisdictions, you have different considerations that you are actually looking into. Like for example, if you look at India, India has a very high mobile penetration, I would say, rate. And even though because of this high mobile penetration rate, the average revenue per user is one of the lowest. That means mobile connectivity is the cheapest in India. So when we are looking at these two factors, then obviously the value which is recognizable by an implementer might be very different from how the implementer sees the value of the implementation in different jurisdictions, where the average revenue per user is in fact could be higher. So there are a different number of market considerations which particularly would have to be considered while deciding what exactly should be that FRAND rate. Now mind you, even though we have FRAND, those four different aspects or considerations that go into defining what exactly should the royalty rate be, it need not be consistent between parties, it can differ between parties. But does that difference or does that deviation in terms of what is being offered as a royalty rate across different parties create a kind of a discriminatory action on behalf of the patentee? That is something which at least the courts have considered, that no, that itself is not in fact a non-discriminatory position which is adopted by the parties, by the patentee. But nevertheless, when we are looking at these variations, when we are looking at these deviations, particularly the state of the market, the economic factors, the extent of the penetration of the technology itself would in fact come into question. So when we have licensing royalty rates, say set in the US versus what are set in the EU, and then what exactly needs to be implemented in India, it would be in fact a challenging task, which would be something which the parties may in fact come together by way of a mediation or by referring such kind of an issue to a third party in order to assess what exactly should the royalty rate be. But by and large, what we see is that that mechanism is something which is available. However, it is something that needs to be exercised, particularly when we have two parties who are willing, or at least there is a general recognition of the essentiality of the patents in question.
Yeah, thank you so much. I would now like, we later on will go into a discussion. It will not be a monologue now by the panelists each. We will later on talk about the various aspects that are brought forward here already and will still be forward by the other panelists. Now Vinayak will talk about their ways. Yeah, okay.
Yeah, good evening all. Firstly, I would like to thank GIPC and Dr. Agrawal for such a nice topic. This is the topic is a fresh focus for the year ahead. So I will give my thought on the recent two judgments by the divisional bench of the Delhi High Court, which really gives the fresh focus for not only year calendar year 2024, but it gives a fresh thought for the SEPs and FRAND in the coming years ahead. So there are two cases. The first is Ericsson versus CCI. Another case is again Ericsson versus Intex. Both by the Delhi divisional bench of the Delhi High Court. So in the first case, Delhi versus CCI, the question is who has the jurisdiction over the patents. Once the patent is granted to a patentee and he started to enforce those patents. So who has jurisdiction over it? Whether the Competition Commission under the Competition Act or the Indian Patents Act, IPO under the Indian Patent Act. So that's what the question before the bench. So what bench has thought, like there are two things to be decided. the anti-competitive agreements and the abuse of the dominant position. So both have been in the law, both patent law and the competition law. But here the question is not only the mere anti-competitive agreements or the abuse of dominant position, but this is in relation to the patents. So when and under patent which is granted under the Indian Patents Act, then what court says that when there is a general maxim, when there is a specialized law is there, then the general law cannot take precedence over the specialized law. So as you know, like in this judgment, the court has given referred to the chapter 16 of the Indian Patents Act. So the chapter 16 has been amended in 2003, which has been later than the Competition Act. So what is the so in this case, court says that as the intent of the legislature is very clear that in relation to the patent matter, the Patent Act should override the Competition Act. So the FRAND licensing and SEP related question has to be solved by the Indian Patent Office. So in this, the sections which are mentioned by the court regarding the chapter 16, as you know, chapter 16 deals with the compulsory licenses, working of the patents and the revocation. So it mentions the section 83, 84, 87, 88, 89, section 90 and section 92. Now, so as you know, the Indian Patent Office currently deals with the technical matter, technical as well as the legal matter. So now with this recent judgment, the IPO has been given additional task of deciding the commercial terms. So now we have to see how it moves ahead, because as you know, there are very few cases in relation to the compulsory license in India. So in view of this, with the additional responsibility, we have to see how it moves in year 2024 and ahead. So I will now go to the second case where Ericsson is involved, Ericsson and the Intex. So here the Ericsson is a standard essential patent owner and the Intex is the implementer. So the single bench has decided in favor of the Ericsson, where the bench has found that the patents of the 8 patents of the Ericsson are essential. Though again those are infringing by prima facie infringing by the Intex, and the court found that the Intex is unwilling licensee, and the offer by the Ericsson was as per the FRAND rate. So then single bench has decided that 50% royalty to be given by the Intex immediately and 50% at the as the security. So both the party again go to the cross appeal in the divisional bench. So here the order of the divisional bench is a very speaking order. So in this order, the court has decided so much of questions. So firstly, it has decided like how to find out the infringement in relation to the SEP patents. So the case is that firstly the court will map the patents with the standards. If the patent matches with the standards, then it is the standard essential patent. Now again, there is another whether to find whether there is infringement by the implementer. What it will do? It will map the product of the implementer with the standard. If it maps to the standard, then it's an infringement. So it's like when A is equal to B and B is equal to C, then the A is equal to C. So that's the indirect way of the infringement that court has found. So now there is another thing, so which Dr. Heinz also telling in his lesson. So what are the duties of the SEP owner and the implementer? So the court has decided a certain way of the duties. So when the SEP owner found that somebody is infringing or implementer is infringing his patent, so what he should send a notice of infringement to the implementer. Implementer, if he found that his patents are being the patents are being infringed by his product, he will send a letter to the SEP owner stating that he is willing to take the license without any condition. So of course FRAND should be there, but without any other condition. Then based on that, the SEP owner should send the offer with the FRAND rates or whatever his offer is there. And to that the implementer gives his cross offer, and after the cross offer given by the implementer, there has to be again re-offer should be given by the SEP owner, and once all these thing has happened and still the implementer is not willing to take the license, then the court says that then the implementer has to give a security in the court. So that's the, and this procedure also says that who is the unwilling licensee, and also say that what are the, whether the duties has been, the proper duty has been covered by the SEP owner. Then another question, the judgment says that whether the FRAND licensing should be of the individual patents, whether it's a country-specific patent licensing should be given, or it's a licensing of the global licensing. So the here court says that it has to be a licensing at a global FRAND licensing. And there are another question. Okay. So, again, another thing, there is a one common misconception, not misconception, there is a one certain condition in case of the SEP patent is that there can be no direct injection can be given against the party. Because as you know, SEP is a standard, and as it is standard, the implementer has to infringe it to get it implemented. So in that case, there is no direct injection can be given, but the court says that it is not a universal law. So if the implementer is unwilling and trying to kill his time, then in that case injection also can be given. And also the court found that the four-fold test in Nokia versus Apple is contrary to the law. So what I think that these are the recent judgment in the year 2023, and it can change the course of the SEP and FRAND in the future, and we have to see how it moves ahead. Thank you.
Yeah, thank you so much. Now we are through because of the first three, or the speeches or contributions of the first three panelists. Now Pankaj, Soni, it's your turn. You are still on the list. And then, of course.
Good afternoon, everyone. Being in my position, I think it's slightly enviable because the panelists before me have actually laid the platform. So there's nothing really that I can add to what has already been said from what's happening in the EU, what's happening slightly in the global scene, and what's happening in India. So I will offer a different thought and a different qualifier in the sense that what I'm about to say, I don't necessarily believe what I'm going to say. But I'm saying it because I think there are certain other thoughts that need to be considered when you are talking about standards, essential patents, etc. First thing is, there's no victim here. I think we talk about SEPs and we talk about implementers, and we're always trying to make out a victim. It's either the SEP is stuck in a situation where the implementers hold out, or the implementers getting a raw deal. At the end of the day, it's business. The SEP wants to make money by licensing, the implementer wants to make money by selling the product that embodies that invention. So the dispute is about money, the dispute is about a business negotiation that needs to happen between the parties. And I think that is fundamentally something that we have to agree with. We can talk about policy and we can talk about a lot of other things, but at the end of the day, it's business. We have to look at it as business. And so the challenge or the thought that people have is how to reduce the transaction cost so that each party can benefit from the deal at the end of the day. And the EU has taken a good step forward. It's come up with these regulations. Now, I don't believe in knowing what I know right now that it's a workable solution for, and part of it, Dr. Goddar, is I'm doing it just to be the contrarian here, is because when you look at it purely from a process standpoint, all you're doing is we have a process in place. Every country has a process in place. India has a process in place. Chitra talked about it and Prashant talked about it. That you can go to court and you have this system of trying to go through this dispute. Why add another forum? Why add another system? So you, rather than saying that let's look at the system that's already there and making it better, I'm telling you that let's create a parallel system that will, the EU IPO will do X, Y, Z, etc. And what for me makes it a little bit more difficult is that after doing all of this, after coming up with a framework that you think will work, you tell the parties, by the way, it's non-binding. So now I'm going to go through X number of months of a process, and I'm going to go and spend time and effort and do all of this, and at the end of the day I could be back at square one. Non-binding, I did everything, I don't like it, now I'm going to go to court. So I'm not sure, knowing what I know today, whether that is the way forward. The other issue with that is, we are all sovereign jurisdictions. Will India accept a decision that's coming out from Europe? Will China accept the decision that's coming out of Europe? Can we have a global agreement? If we have a global agreement, I call it a sort of a utopia-based framework. If everybody agrees, we should have it. But I don't think it will have that. And so what will happen is, you go through this thing and you come, and then you can go to China, and China will say, oh, by the way, there's an anti-suit injunction that my court has already given, so what do you do there? But there are a couple of points that I noted here, which I think is something that we have to start thinking about. One is, and India can do it, because as Chitra mentioned also, that India is leading the way. We're making it easier at some level to manage SEP battles in India. Why not, for example, have an SEP holder, when they file the suit, attest to the fact that we agree that when the court identifies a rate, it is a global rate. We as an SEP holder have enough confidence in the jurisprudence of this country to say that you define the global rate so that I don't have to go and fight 10 battles. Is that a solution? I don't know, but that's definitely a thought. It came up in the recent Nokia versus Oppo case, so why don't we think of it in that way? The sophistication of the implementer. Dr. Goddar gave you the steps that the EU draft regulation has, and those are great steps. But that is on the assumption, and you have to know that Germany is a very sophisticated market. The implementers there, the names that were taken, they have been in business for decades, if not a century. And they're very sophisticated, they know the process. You flip it to a country like China, you flip it to some country, to some entities in India who are not sophisticated implementers. How do you know that they are not there to beat the system? How do you this system will work if the parties are sophisticated and they want to achieve that end goal of the best license agreement to take it forward. And if that doesn't happen, then I'm not convinced today that a global framework like that, or a supposedly global framework under the aegis of the EU IPO will actually work. And so with that, I hand the mic back.
Yeah, thank you so much. But you see, persons, firms, litigators who work in this field are very seldom of the same opinion. It depends to whom you talk. I will try to behave as a moderator as neutral as possible. So I have a firm opinion, but I will not disclose this firm opinion. And now we come to you, yeah?
Thank you, Professor, and my co-panelists for sharing their views on Indian cases. I would like to take a different topic. I would like to focus on how data is going to play a pivotal role for Indian companies while determining the licensing rate over a couple of years. So there are three main approaches which are used. The first one is the comparable approach, where comparable licenses between like similar parties in similar patents is used as a reference to award the licensing rate. But for India, that kind of information is very limited. The contract and the value which has been offered. All we have is the international or the US contracts, and those are also limited. The second approach is the proportionality approach. So it has like every patent is valued separately to determine what value it will bring to a standard and what the standard will bring to a product. So if we add value of every patent which might be present in a single product, it is likely that the overall value might go over the product value. So that's a Roy stacking problem. So the third approach is the top-down approach, and it is like used in multiple cases, and also the European Union Commission is inclined towards that thing. So in this approach, they are looking at the aggregated royalty burden. So Dr. Heinz already mentioned about that thing. So it's a value a technology brings to a product. So in a 5G phone, what the 5G technology will bring the value to a 5G phone. So what like whether it is a $10 value in the $200 phone or not, kind of thing. So once that value has been determined, that value is distributed among the SEP owners based on the percentage ownership of their SEPs, actual SEPs. So to give you an example, for 4G, let's have a 8% aggregated royalty burden, and if there are like 6,000 self-declared patents, and after evaluation we find that there are like 1,000 patents which are actually essential. And if a company A has like around 100 patents out of those 1,000, they have the point per portion. And if we multiply that 0.1 with the 8%, it's a 0.8%. And considering the average selling price of the smartphone as $200, then $200 by 0.8% is $1.6. So that's the value which company A will get for their portfolio, $1.6 per unit. So we need to understand there are like two main aspects, the main factors which are present here. First is to understand whether the patent is actually essential or not. And the second is the ratio a specific SEP owner has in that SEP landscape. So coming to the first one, the essentiality analysis. So like there are self-declarations. So it means like whenever standard is getting developed, members submit their contributions for the standard development. And all those like with the contribution, they also need to declare the patents. So all those declarations are not actually essential. The reason is that like whenever they submit the declaration of the patent might be at the application stage. So as the patent prosecution goes on, the claim might get changed. And also the contributions which are submitted, all those contributions will not get accepted, like just a portion of that will get accepted. So at the end, like only 10 to 20% of the patents which are declared are found to be essential. So this is again a big task if we look at the worldwide level. And for that, companies should have a big teams with the technical expertise, and also unbiased opinion is needed. So whenever you are in arbitration or court, you cannot just go and show your own evidence, because there is again a different side. You might have biased that analysis. So in that kind of thing, companies rely on a service provider like us, Clarivate, where we provide them an unbiased analysis about which patent is actually essential to the standard, like creating that claim chart, like patent to standard mapping kind of thing. The second main factor in the top-down approach is the understanding the percentage ownership of a specific SEP owner in the SEP landscape. So mostly companies rely on the reports available in the market, like which company is the leader, like how many patents are essential in a specific technology. And those reports you will see, those are like worldwide families or US patent or EP patent, but you will rarely see some reports mentioning about how many patent families are present in India. So that's one data point which is missing. And the reason I believe is the poor coverage of the in-part of family. So normally when a patent owner disclose their patent to the SSO, they have to only declare at least one patent. So to understand like what is the coverage of the SEP, companies rely on the in-part of family information or the simple family information published by EPO. But that information is not good for India. So to give you an example, we looked at the data till December 2022 for 5G declarations. So there were around 60,000 patent families which were declared. But surprisingly, when we looked at the Indian patent, out of that, only 1,000 patent family had the Indian patents. So it does not mean there are like 1,000. So we understood there is a gap. So we use our Derwent data, Derwent family. It present in the Derwent innovation. So it is a manually curated family based on the claim scope and the priority information. They club those patents into a group and call that as a DWF family. So we were able to uncover additional 17,000 patents. So we started with the 1,000 patent with the Infodom, and with the DWPI we had around 17,000 patents. So I would request like for Indian companies who are getting into the licensing, have a right tool to understand the data for the SEPs. Otherwise, you will be stuck with like 1,000 patents, but there are like remaining 16,000 or 18,000 patents which are available, and you are missing that. So have a right tool. The second point I want to mention is that not all the SEP families have patents in India. Like wherever you see the report, like only 30% of the declared family have a patents in India. So remaining 70,000 families, 70% families you don't take care. And if you look at the granted family, so the statistic which I was mentioning about the published plus granted, but for granted it goes below 10%. So among the granted families across the world, only 10% families have Indian presence. So that you need to understand. And also, not all the assignees have patents, like all the SEP owners have patents in India. So whenever you are negotiating any licensing deal, make sure that you understand the coverage, whether it is matching to your market or India, because only 50% of the patent assigned, the SEP owners have patents in India. And because of all this thing, you will see the distribution of SEPs in India is completely different from what we have across the world. So companies like Qualcomm file more than 50% of their portfolio in India, but there are many companies which files less than 50%. So if you are seeing some ratio, like if X company has like 10% of the SEPs worldwide, but that number will not stand for India because they have a different strategy for India, and other companies also have a different strategy. So because of that, the ratio will change. So you need to understand whatever information you are looking at the market reports will not be helpful for you in negotiating the deals in India. The fifth one I would say is understand the ecosystem, where your product stands in the entire ecosystem. So to give you an example, like if you are an automobile company in a connectivity space, you are mostly in the user device side, not on the base station side. So in a patent there are like user device claims, there are base station claims, or some patents have both the claims. So in a telecom, like around 80% of the patents are related to user device and 20 are related to base station. So you are not going to infringe on those 20% patents, right? So you need to just care about those 80%. So again, if you see the calculation, you are reducing that to the 80%. And I think it is same for the coder and decoder thing again. The last one is about understanding the markets in which you operate and where the SEP has been protected. So Indian companies mostly operate in Africa, Central America, Southeast Asia. But if you see the SEP coverage in those areas, like very different. So Europe, like IP5 country has a good coverage. Then the next coverage I believe has in India. If I'm considering the DWP data, then India, then Brazil. Brazil has the 10%. And if you go to Africa, it is a single digit coverage. So whenever we are discussing the global licensing rate, we need to understand which market we are present, whether there are SEPs or not, whether we need the licensing like negotiations or not, or get into those like costly rates which are offered by patent pools or the SEP owner. So I believe if Indian companies use these strategies, they will be able to negotiate better. So I have seen that while working with the top SEP owners and the key SEP implementers. And I think this would be the like one of the things you need to keep in mind over the next 2-3 years. So I will be happy to answer any of your questions related to data. Yeah. Thank you so much.
Yeah, thank you so much. As I said, I cannot tell you my own position, but I will tell you one thing. The experience we made in Germany and continuously make it with mandatory arbitration. We have this in our employee invention remuneration system all the time since 1942. That means you must go any conflict between an employer and an employee concerning the justified, the reasonable, I don't know what, remuneration which the employee inventor should get, the share of the commercial value of the invention of the employer must be shared with the employee, and that is always a dispute, and you cannot go to court in Germany as long as the employment contract is still existing, but you must go into a compulsory or mandatory arbitration procedure at the German Patent and Trademark Office. There is a board of arbitration for employees' invention, which is binding again. So if somebody is not satisfied with what the employer at the end of the day of negotiations between employee and employer is offering to the employee must go to the board of arbitration. That is a cheap procedure. You don't need lawyers. You have examiners from the patent office, economists sitting there, and the transaction costs at the end of the day are very small because of that procedure, where also industry participants are coming from trade unions, from employer organizations, and it works perfectly. We have in Germany about 60,000 employee invention per year. That's more, by the way, than all the inventions together in other European Union countries made at all. And we have about 200 cases per year which are being brought to the Board of Arbitration. 200. They make a proposal. And this is exactly what is also here in this procedure the Commission is proposing. That means they make a proposal, and then you can go to court. Out of these 200 cases per year in Germany, results being published, always resulting in, and this is where we have our wisdom, if you wish to say so, of reasonable royalty rates for car tires, for injection systems, for medical instruments, for pharmaceuticals. This is published every year. 200 cases, you know, since decades, what the reasonable royalties there would be, and there's a specific provision in the German law when determining the reasonable royalty, binding again in Germany, binding law, you must consider the maximum amount, aggregate amount of royalties that a product can carry in order to be competitive in the market still. So there is a limit. You have to go exactly the way aggregate royalty, what is the maximum amount, and I cannot deny that this regulation has been strongly influenced, I would say, not because the Director General of DG GROW is a German, Kerstin Jorna, whom I know pretty well, but this is just the German system. We have done this all the time. But the point is, only 5 cases go to court. So we would take really the profit-making business of the big litigating firms away. This part of the transaction costs will disappear if the present system is replaced by a system which is now proposed by the Commission. So mandatory, yes, but it is not really mandatory, also not in the EU proposal, but it is only a step before you can go to court. And there are time limits in that. It cannot delay the procedure before you can go to court by more than, according to the present proposals, by more than 15 to 16 months, and that is maybe the time people need to negotiate anyway. So, I think, personally, the threat of the proposal is not against the implementers. It is not against the people with huge portfolios. It is a threat against litigation industry. And I'm the senior partner of a rather big law firm in Europe also. I think we will not earn our money or a substantial part of it in future anymore out of SEP litigation. One just has to look into the hiring policy, and whatever you do, this will go away. I have personally no doubt, but let's see what happens. But now one thing, and I will ask the panelists later on after this little contribution I make, a certain question. And that question is one of the basic questions the proposal of the EU Commission seems to address, and which has been addressed by the Düsseldorf court many times already, and whenever they bring the case to the European Union Court of Justice, the parties settle, whether it is Daimler, Nokia, or ZTE and Huawei, they never come to the European Union Court of Justice, which is a mistake of the European system. The court should have the authority to continue such a case, even if the parties withdraw. They can go away. This is, by the way, also one of the proposals how the European Union legal systems should be modified. Now, that question is, does the FRAND obligation, fair, reasonable, and non-discriminatory license, which is necessary according to everybody, the implementers, the SEP owners, in order to avoid by abusive behavior any, let's say, refusal of or be too difficult access to a technology. Does this obligation mean license to all, or does it mean access to all? And I give you the explosive character of this question. If it means license to all, then comes the chip manufacturer, my dear Intel chip manufacturer or TSMC or whatsoever, and they ask for a license. They ask for a license by Qualcomm, Ericsson, Huawei, I don't know. They ask for a license, and then they will say, yeah, we are prepared to pay 10 cents maybe per chip, because the chip costs only when they sell it 10 euro or something, so maybe there is a reasonable royalty. If that is for a mobile phone, and Intel, let's say, uses that chip to give it to a phone manufacturer, maybe that is a reasonable, very reasonable calculation. But now they give this chip to Mercedes. They build it into their S-Class. and the car is sold at 100 or 200,000 euro, and they get now this wonderful little windshield, miraculous windshield processor at 10 cents licensee. It's ridiculous, absolutely ridiculous. So if they would go directly to Mercedes, they would get 15 euro. That's exactly the price at the moment being negotiated for that chip in terms of royalty, and not only 10 cents. How can we solve that? Possibly one can solve it, and this is a big discussion in Europe at the moment. One can solve it by a possibility, and nowadays it is technically possible, that the chip manufacturer get this license only for cases where the chip manufacturer sells this chip to a phone maker. Let's put this cheap way. And if they sell it to Mercedes or so, they have to add a additional component, which can be much bigger possibly than this basic royalty which was paid originally. And then until 5 years ago, they all said, the chip manufacturers and the implementers, we cannot control this. We need reports from the users of it. This is much too complicated, much too complicated. Today, when you ask in Santa Clara or in Hsinchu or you ask in Shenzhen, no problem, we know this. This is all technically built in. We know where it is being used later on. So one could technically solve this problem of later on supplemental payments in case that something that originally envisaged between the two contractual parties would be used. And maybe that is a way how to use it. But question is access to all or license to all, because access to all you also can give if you only license out as the licensor, that means the owner of this SEP, if you license only to the S-class manufacturers, then everybody has access, because then they can buy under their license from whomever they like, and they go up the chain and buy it from Mercedes at the end of the day. But license to all means whoever comes to you, you have to give a license. And then we possibly need a balancing mechanism to take care of this otherwise abusive behavior that you pay a royalty for the innocent use in a mobile phone, but later on it is an important component in a super luxury car or so. Maybe that is the way in which discussion has to go. My personal opinion. I ask now, everybody sitting here, should we have, under FRAND conditions, license to all or access to all? What does it mean? I know what your clients say, or my clients. Just what is your personal opinion?
I see Dr. Agarwal is also very anxious right now because we're way above time. But I think it should be based on the technology.
Everybody has to do a confession now here.
I like the chip example where the mobile phone usage on the mobile phones pays a different royalty rate, and the one on the S-class pays a different royalty rate.
In my view, I think so a hybrid approach may be perhaps a more less resistive way to proceed forward. And right now we are only looking at telecommunications and the automobiles, but as technology, not only in these fields progresses, we may have a different mechanism altogether. We have electric vehicles, we have their interfacing with the general infrastructure, the electrical infrastructure, all those kind of issues, technology challenges will have to be factored in. So I think so I'm sort of chickening out and taking an easy answer, a hybrid.
Because this is a company who is on both sides, like my dear clients in Shenzhen, the same thing. Big portfolios which could wonderfully be monetized. On the other hand, the need also to get licenses under SEPs from others. What is your opinion? License to all or access to all?
He's putting me in a very difficult spot, and he also knows who my boss is. I don't know how to manage this question. So I would just say very simply, we have to do what is reasonable to both the parties, and I'll leave it at that. Because anything I say could be used against me.
Okay, so very difficult question, but I can try to answer. It is a license to all, but like as Gaurav has told, like suppose a company who is selling his product in a Southeast Africa or Asian countries where the SEP patent filing is very less. So for them, like even the rate of royalty given to the mobile manufacturer and to the automobile manufacturer, so it has to be different. Not even though they say FRAND, but it has to be different because the market is different and their use is different, their numbers are different. So license to all, but FRAND has to be FRAND for based on the how much quantity, how much market, how much he's also earning. So depend on that, it has to be given. So that's my opinion.
So I will share my personal opinion, not the Clarivate opinion. Yeah, yeah. So I believe like in a mobile phone, since you gave an example, like the communication is the thing. Without that, that phone or that device is not of no use. But in a like vehicle, there are other technologies which are very important. So first that vehicle has to be moved, then the connectivity is important. So we need to understand like which all technologies are present in that product, and then accordingly see like what the patent is bringing the value there. So in a phone, like the patent might be more valuable because that's the core technology. But for a vehicle, that telecom patent might not be the core thing. So accordingly, you can decide. Yeah.
Yeah, maybe you need my confession also. I mean, I must first say Clarivate, they are one of the beneficiaries of the whole new system if it comes, because they have chosen now not to determine the essentiality by classical methods, by chart analysis, etc., of each and every self-declared SEP. That's much too expensive. We also offered by my firm, many firms that it costs 10,000 per patent. It is really euro or US dollar, much too expensive. But they say whoever declares SEPs more than a certain number, and then he has to designate, let's say, 100 per year to the IP competence center, and then check those, and then you get a credibility factor. That means if all of them are really standard essential, it is assumed that the other 10,000 you have declared also are, rebuttable of course, also are real SEPs. And if not, if you have a credibility factor of 0.1, every tenth only of the checked ones is really standard essential, that credibility factor comes to the rest, and then you can estimate what a court would make out of this later on when you come and say, oh, they say themselves that phone can talk with somebody else, so they infringe. Very interesting thing. So my confession is, I believe in I believe that there should be a license to all obligation, but with this modification, the contractual one I have talked about, I think you have guessed this already, that later on you have to pay more if you deviate from the originally agreed field of application. That's my personal, I'm educated as a Roman Catholic. If I am wrong, there will be forgiving some authority later on. This is what our church does, but this is my confession for the moment, which would be a use for this. I thank all the panelists, I thank the audience. I think we cannot ask the audience for questions anymore. I would love to do so, but I need
sorry, but for the paucity of time, we cannot really take the question and answer session. We guess we can interact in the dinner session maybe, and probably some questions.
One offer then. All of the panelists here, I assume they will not dare to disagree now, will be happy to receive answers by emails over the next days, weeks, even years. Whatever has to do with these questions we are discussing here, which are not easy, and then we will, without charging, if it is not an individually to be solved case, we will then answer this question. One question I must allow. You have all the time already raised your hand. As one question I must allow. I feel morally obliged as the moderator. Please, go ahead. Short. Question, not another lecture. You need a mic. It is otherwise not understandable, even not here by the panel.
Yeah, thanks to all the panelists for sharing your views and experience in that SEP filing of patent application in India. I wish to add one more point, that Indian judicial dispenses, to proving the threshold of proving infringement is too high if you are comparing to Western countries. I hope that is very much impact in that. For in-licensing, also filing patent more in India. If you are their portfolio in US, that's Apple company, they have filed more than 50, 60 patent in US, but in India you can file only 5 to 6. Because they know if somebody is infringing the product in India, the judicial dispensation in India also as per the standard law and regulation, it's very difficult to them to prove it's a complete infringement. I hope that's also an important point in that aspect of SEP filing.
I promise, I hear already from my right side, very important. It is all very important. We could continue for at least 2 hours, and I promise you, nobody would feel really bored, but we cannot do this. I would like to ask the organizers for forgiving us that we overdid our time here. It was for me at least exciting, interesting, and sorry that we took so long, but I think it was worth it.
Thank you so much. So we're wrapping up this enlightening session. May the knowledge shared today be the catalyst for innovation, and definitely gratitude to our knowledgeable panelists for their invaluable insights, shaping the success of this discussion. A big thank you to our experienced moderator for facilitating a seamless and enriching discussion, and also his valuable inputs as well. So Professor Dr. Heinz Goddar, thank you so much. I request Dr. E.P. Agarwal to please felicitate Professor Heinz Goddar for moderating this session so beautifully. I'd also request Dr. Agarwal to please felicitate our speakers for this session, Ms. Chitra K. Iyer, Director, Licensing Program Leader, Phillips, thank you so much, ma'am, for joining us. Mr. Prashant Phillips, Executive Partner, Lakshmikumaran and Sridharan Attorneys. Thank you so much, Mr. Phillips. It is indeed our pleasure having you. Mr. Vinayak, Patent, IPR and Innovation Leader. Mr. Vinayak. Thank you so much, Mr. Vinayak. It was indeed a pleasure having you two in the program. Thank you so much for your valuable insights. Mr. Pankaj Soni, Partner and Head, Patent Litigation, Remfry and Sagar. Thank you so much, Mr. Soni. And thank you so much, Mr. Gaurav Sawant, Associate Director, Patent Search and Analytics, Clarivate. Thank you so much. Thank you so much, everybody, for joining us in this session. It went on for a little longer than we had expected, but it was, of course, a wonderful session. It was indeed a pleasure having all of you in the program. So thank you so much, everybody. Since we have paucity of time, we are going to continue with the next session. We'll probably take a minute break to just because the next session is a very, very interesting one. That is the debate session. The debate is on topic trade secrets or open innovation.